Hello, my name is Jeff Skolnick. I am an attorney in Baltimore, Maryland. Recently, I successfully defended a defendant in a debt collection case involving an old credit card bill. In that case, my client did not remember ever creating the debt or being served with the suit papers. We reached a favorable outcome because we demanded strict proof that could not be provided by the plaintiff for such an old case. As a result, the attorney for the debt collector had to drop the case and dismiss the claim. In a set of facts that is stranger than fiction, my client received a notice of garnishment relating to this very old judgment filed against her. She insisted that she had never been served with the original lawsuit. After I entered my appearance, I went down to the court and copied the notice of service by the private process server claiming that my client was served with the lawsuit way back in 2004. My client denied ever getting this paperwork, and something seemed a little strange about the notice of service. Out of curiosity, I Googled the process server's name to see if he was even still alive. Much to my surprise, he had been a police officer who went to federal penitentiary for his involvement in a massive fraud scheme involving kickbacks from a towing service. So I sent an email to the attorney for the debt collector, asking him if he had an address outside of jail to serve the process server with a subpoena so that I could bring him into court and cross-examine him about the case. I attached the link to the newspaper article about the fraud case involving the police officer. I also asked in the email to the plaintiff's attorney if his private process server was still in jail so that I could issue the correct subpoena. The next day, I received a response from the attorney for the debt buyer saying that he did not wish to proceed with the case any further. He wanted to know if we would agree to a dismissal. Before we consider agreeing to that dismissal, I also had to consider whether my client had a cause of action for violation of the Maryland law or the Federal Fair Debt Collection Practices Act. My client actually did not want to proceed with the lawsuit, and she wanted to just end this litigation. So in this case, we dismissed it in a way that was beneficial to my client's credit score. The main point is that nothing can be taken for granted in these debt collection cases, and you should hire an attorney to help you unravel the mystery associated with these debt cases. You need to demand strict proof of all parts of the case and show up for court, especially if you do not owe the alleged debt. Under certain circumstances, you can actually turn the tables on the debt collector and sue them for violations of the Maryland and Federal Fair Debt Collection Practices Act. So, if you have any further questions, please go to my website, skolnicklaw.com, or call me at the number on my website. Thank you.